Okay, Samridhi Talwar.
Good afternoon, sir.
Good afternoon, Smriti. How are you?
I'm good, sir. Thank you.
Uh, Mr. Saget, are you there?
Yes, sir, I'm there.
It was not visible. Okay, can start. Smriti, briefly tell about yourself, your introduction, and your family.
Right, sir. So my name is Samridhi Talwar. I'm from Delhi. I did my schooling from Mount Carmel School, Anand Niketan, and I completed my schooling in 2017. Thereafter, I pursued my BBA LLB from the main campus of the Guru Gobind Singh Indraprastha University. I completed my LLB in 2022, and ever since then, I have been preparing for judiciary. Regarding my family, my father is a senior accounts officer in the Ministry of Finance in the Government of India, and my mother is a teacher in a government school.
Okay, you're a single child?
Right, sir.
Okay. Why you are interested in coming to judiciary?
Yes, sir. Ever since I entered law school, I had dreamt of being a judge. And that dream became a sense of a passion and a goal when I interned with an additional district judge in the Tisazari court. It is there where I firsthand saw the role of a judge and how a judge dispenses justice upholding the rule of law and sees an impact right in front of his eyes. So that influenced me a lot, and I felt like that is my calling and that is what I would like to do. So that is the reason, sir.
Okay. Why you have not tried for being an advocate?
So I acknowledge that an advocacy is very, very indispensable in the justice delivery system because a judge cannot decide until an advocate brings out the appropriate facts and evidences before the judge. But I always felt myself being more inclined towards judiciary. Even when I interned in college with various advocates, I always saw myself, envisioned myself on the other side of the bench. So that is the reason, sir.
Okay. Do you know that number of cases pendency in India is going on increasing day by day? What reason you attribute to it, and what solution do you suggest for the same to improve upon?
Right, sir. So there is a lot of pendency at all levels, from Supreme Court to the High Court to the district level. Major reasons for the same can be one, there is a lot of enhanced litigation because as more and more population is educated and is aware of their rights, there are increased litigations because of that. Secondly, there is a lack of judges because there are a lot of vacancies in the judiciary at every single level. Another reason may be that ADR is not at alternate dispute resolution is not adequately implemented, and people are not aware of that. And
Hmm.
also, so government being the largest litigator is also one of the causes for a lot of pendency and a lot of cases being filed. And certain solutions for the same can be one that we can implement case management hearings, as is been provided for in the Commercial Courts Act and was also recommended by the President of India recently. The second can be that in courts the judges can inform parties, and otherwise also awareness campaigns can be led for ADR where parties can be informed of the benefits of the same. Another reason can be government can exercise a sense of restraint towards litigating. Am I audible?
Yeah.
Sorry, the screen was stuck. Yeah, so the government can exercise a sense of restraint in certain cases by not seeking further recourse if a judge has decided something. And lastly, so the vacancy of judges can be filled more promptly so that the full strength can work on the cases that are pending. These are some I can think of, sir.
How do you feel that the judiciary reforms can be made, and how technology can be used for the same, for improving upon?
So, judicial reforms Firstly, so as you rightly said, technology is very imperative in the implementing of judicial reforms. And there are a lot of measures that are currently being implemented because there's a huge budget that has been allocated for digitization of courts. There is the National Judicial Data Grid, which shows how the pendency of cases every day. The Supreme Court also has software such as SuPass software and Suve software. The first one is for research for judges, where judges can access judgments very easily. And the second is the translation of judgments. Both can be done for district courts as well as high courts also, sir. Apart from that, as the Delhi High Court had recently said, we can have, because public prosecutors are also a facet of a part of the justice delivery mechanism. The Delhi High Court has recently said that we should have electronic libraries for public prosecutors where they can effectively manage cases. So that can be implemented, sir. Apart from that, further stress on electronic hearings can be done, such as has been promoted in the Bharatiya Nagarik Suraksha Sanhita. In civil cases and other cases also the same can be done. These are a few things I can think of, sir.
Okay. One question on what if a high court refuses to comply with the binding precedent of the Supreme Court?
So, if that is the case, the judgment that shall be given by the High Court will be per in curiam and thus will not be binding, sir.
So they are refusing to comply with the Supreme Court judgment.
So, in such a case, the party can directly approach the Supreme Court, and then the Supreme Court can give an appropriate order for the same, sir.
Under what this thing article?
So, it can be as part of the special leave petition under Article 136. Uh, yes, sir. Or under appeal also, sir. If it's a civil case, then under Article 134 or 133 or criminal under Article 134.
Not under Article 142.
Right, sir. I apologize, sir.
Hmm.
Yes, sir.
What if if Parliament passes a law banning the social media criticism of judiciary, would it be constitutional?
No, sir, because if in criticism, we are in a democratic country, and criticism and dissent are part of a democracy. So, if Parliament bans any criticism with regards to Supreme Court, if it does not fall within the mandate of Article 19(2), the reasonable restrictions, then further restrictions are not appropriate, and the law can be challenged. However, if the law of the Parliament falls within the four corners of Article 19, Clause 2, then the same may be permissible.
How the evidences are being pursued in the court
Right, sir.
and the type of evidences.
Right, sir. So there are the Evidence Act defines two types of evidences primarily: oral evidences and documentary evidences. Electronic records are also part of documentary evidence. For oral evidence, Section 59 and 60 of the Indian Evidence Act govern the same, which say that the oral evidence may be given for any fact other than the contents of a document, and the same must be direct in order to avoid hearsay evidence. For direct evidence, for documentary evidences, so section 61 onwards govern the same. The document can be proved as per section 64 by primary or secondary evidence. Secondary evidence can only be given in cases where primary evidence is not available and the case falls under section 65. Apart from that, electronic record is governed by section 65A and 65B.
What type of jurisdictions courts we are having?
Right, sir.
Jurisdiction.
Right, sir. So, for district courts, there is the civil jurisdiction and there is the subject matter jurisdiction, which contains civil or criminal cases. Then there is the territorial jurisdiction, and then there is the pecuniary jurisdiction, sir.
And how many types of writs are there?
So, there are 5 types of writs, but it is not exhaustive, and other types of writs can also be applied by the court.
So, what you will suggest for, in your view, the judicial transparency can be there by streaming the proceedings of the court?
So yes, sir. As it was held in Swapnil Tripathi versus Union of India, sunlight is the best disinfectant. And if cases which do not infringe on a party's personal rights, such as personal information, such as cases of domestic violence or family-related matters, other than these matters, cases can be live streamed, and that will instill better confidence of the public in the judiciary, sir. In my opinion.
Mm. In your opinion, what is the difference between decree and order?
Right, sir. So Section 2, Clause 2 of the CPC defines a decree and 2 Clause 14 defines an order. Decree, the major difference between the two is that decree completely and conclusively determines all the rights and liabilities, and no further proceedings lie for the same on the issues that are dealt with. Whereas orders are not conclusively determining any per se right, and generally orders are procedural, whereas decree deals with both substantive and procedural rights, sir.
Mhm. So, if you are a judge, whether you will be deciding the matters on merit or you will be coming under pressure on account of political and other factors or uh, this our media.
So, I would try my level best to give as impartial a hearing as possible. And if there is any case where I feel I am being pressurized, I would recuse myself. Yes, sir.
Okay.
Hello, Samriddhi.
Hello, sir.
Samriddhi, what is that, one thing that attracts you, to be a judge?
Right, sir. So it is the impact, I believe, because one upholds the rule of law and one can see an impact right in front of their eyes. Of course, there are pecuniary benefits and there are other benefits, but apart from that, sir, there is a sense of a purpose that is being accomplished, sir. There is a betterment that is being done, and that gives me, I believe, is a satisfaction from my profession that I would really like to have, sir.
But don't you think, let's suppose you being MM pass a judgment, very next day they move in appeal, get a stay, eventually matter gets pending for so many years, ultimately culminating into judgment. So that impact you have was only for a day.
So, I would like to disagree, sir, because my role as an MM is to do my job, which is to give the judgment that I am supposed to give within the four corners of the law. And a party has a right to appeal if it is provided in the statute. And what they do with my judgment, apart if they wish to appeal to the same, that is their prerogative, sir. I would like to still come in every single day and give see the matters before me and try to give judgments and orders to the best of my abilities, sir.
But why not a practicing lawyer?
So it is, I acknowledge that advocates have a very important role in the justice delivery system and the judges cannot coexist without lawyers. But I have always found myself inclining towards judiciary. And yes, sir, that is the only reason. I feel
Why?
judiciary is my calling, sir. I feel it is
Why?
my calling.
Why?
So it's because I feel my skill set is better suited to be a judge, and my way of life, the way I've been brought up, I think it is more suited to being a judge. My parents have government jobs, and I'm very okay. I'm very comfortable with that way of life, and so one reason is that. Secondly, I feel being a judge, I will be able to impact more people, and also
You don't want to struggle professionally.
sir, not at all, sir. That's not the case. I believe a judge also has enormous workload, and I don't think we can say that. I would not like to
They are
say.
fairly secure in income, other perks and privilege, which an advocate is not.
Sir, that is a fact, a facet, of course, sir. But I believe the purpose is a bigger drive for me, sir.
Okay, all right. What are your views about All India Judicial Service? Should it be there?
Sir, I believe that All India Judicial Service is provided under Article 312 of our Constitution, and if it can be implemented, then I agree that it can benefit the way the vacancies are handled, and also give a uniform procedure. Like for example, in UPSC, there's a uniform procedure which happens at a scheduled time. I think All India Judicial Services will be able to benefit, will give benefit of the same. So yes, sir.
So will it result in better judges?
So I don't think better judges is the question here. I think the judges right now, also the way they are appointed, are really good judges, and I don't think it will result in better judges. I think it will result in better procedure of implementation of appointing of judges, a more uniform procedure.
All right. All right. Up to what stage a court can modify the charges?
So court can modify charges under Section 260 up to before until before judgment is passed.
Before judgment, court can modify.
Yes, sir.
Okay. Where is the provision of discharge provided?
So discharge has been provided for in all in trials of court of session under Section 227. It has also been provided in trials of a judicial magistrate in both complaint cases as well as warrant cases. I apologize, I can't recall the exact sections for the same. However, it
Okay,
is
that's
not
okay.
provided in summon trials.
All right. What is the pecuniary jurisdiction of Delhi High Court?
So Delhi, I believe it can try matters above 1 crore, but I'm not very sure. I apologize.
Okay. Recently, we have seen a misuse of Section 498A because, courts also pronouncing that many frivolous cases are being filed. So, what needs to be done to, address this menace?
So one thing that I can think of is, as per the Lalita Kumari dictum, preliminary inquiry can be held for such cases before FIR is registered, so that the police can prima facie make sure that an offence is actually committed or not. And also, so I think awareness and sensitization can be done both in judicial academies for judges, as well as generally for police and the public, so that they're aware of the ills and the fact that if a false case is filed, the party who files the case can also be held liable.
Okay. Is it really possible in our system that a party who has filed a frivolous case can be held liable?
So the tort of malicious prosecution does provide for the same, sir.
So, in the recent new criminal laws, the offense of sedition has been done away with. But in place of that, there are many other sections they have added, that act endangering sovereignty and integrity of India, involving very subjective interpretation. So, do you think it does more harm than it benefits?
Sir, I don't think so, because while sedition had penalized any comments on the government elected by law, the same as form of dissent is permitted now. However, any comments on ill comments on India as a whole, the country as a whole, have been prohibited. So I don't think that it is going
So,
to do
do
more
you
harm.
do you see any sense of subjectivity on comments about India?
Of course, sir, there is a sense of subjectivity, sir, but that is where I think courts come into play, and that is where courts can exercise their discretion and judge whether a case falls under the particular section or not.
Okay. Uh, do you think death penalty should be abolished?
So, although death penalty is provided under Section 53 and is also a reasonable restriction as per the procedure under Article 21, in my opinion, sir, I think it should be done away with, because there's a sense of subjectivity that is involved. And in no trial can we say that there was no error at all. So, I think that taking of a life of a person is a very grave thing, and instead of that, we can have other forms of punishment. For example, now community service has been added, the same can be implemented. And also, sir, there's no evidence per se that countries which have death penalty have lesser crime rate as compared to other countries. So I think it can be done away with, sir.
Uh, why are the sexual offenses on the rise? Even after Nirbhaya judgment, we amended the laws, we amended Evidence Act also. We tried to do things in a better way. But still, if we look at the NCRB data, it's on rise only. We have not, really been successful in attacking that. So how do you think, like, where are we wrong?
So I think, firstly, I think there is because of there is a lack of awareness among people regarding the law and how it is very stringent. One is this facet. The other, sir, maybe that um, trials in trials take a lot of time, oftentimes, especially in sexual offense cases, even though they should be in a sense fast tracked. So it forms a sense of fearlessness in the mind of a person who might commit the offense, and rather than serving as a deterrent for the same. So if trials are fast tracked, the same might help. Yes, sir. This is what I can think of.
Okay, that's it from my side.
Right.
Uh, Smriti, what is culpable homicide?
So, Section 299 of the Indian Penal Code defines culpable homicide as when a person by any act or omission takes the life of a person with the intention of causing death, or with the intention of causing bodily injury that is likely to cause death, or with the knowledge that the act is likely to cause death.
What is culpable homicide amounting to murder, and what is culpable homicide not amounting to murder?
So, Section 300 defines culpable homicide amounting to murder. It is a subset of culpable homicide not amounting to murder. Culpable homicide amounting to murder is a more grave form of culpable homicide where there is a greater form of intention and knowledge. The definition per se of Section 300 is if culpable homicide is caused with the intention of causing death or with the intention of causing bodily injury that the offender knows is likely to cause death, or with the intention of causing such bodily injury that is sufficient in ordinary course to cause death, or by committing an act that is so imminently dangerous that it must in all circumstances cause death. So, murder is just a graver form of culpable homicide.
So, rape and murder, as has been done in Arjikar Kolkata matter, and you just said that why one shall take, state shall take life of a person, so death penalty shall be done away. But he has also done death and the heinous crime knowingly. Then why? Then at the present law says that the rarest of rare case death penalty can be granted. Then why it shall be done away? You said, no? In your opinion, you said. On what ground your opinion? Is it a person who is doing something wrong knowingly, intentionally? Then sufficient punishment. See, this is the reason why in India the rate of crime, what sir has asked you, is growing, is not under check. See, Dubai is a country where it is declared as no crime country
Right, sir.
because fear of law is there. Strict laws are there. So it is, of course, your opinion. I cannot say, but the rarest of rare case. See, if you want to reduce the number of criminal cases and other things, then strict laws are to be made and enforced
Right,
by
sir.
both executive as well as the judiciary. This is
Right, sir.
and one question I asked you regarding AI and this thing. So, if suppose tomorrow AI starts giving the judgments, then what will happen?
Sir, this was dealt with by the Delhi High Court in a recent case of Christian Louboutin versus Messrs. Shoe Boutique, where Justice Pratima M. Singh had said that AI cannot replace judges and it cannot even replace advocates. AI can at best be used for research purposes, that too a preliminary research. So I don't think it is very suitable for AI to give judgments because one, AI is also fallible, and how AI is making decisions might not be very certain. The data that is fed into AI on which it learns, that we are not very well aware of that data. And irrespective, sir, the human element in judging must not be done away with, in my opinion, sir.
Okay. Thank you.
Thank you, sir.